Hello, everybody, and welcome to the latest edition of Breaking Ground, our bite-sized webinar series. Today's topic is all about rough justice, and it's about the construction adjudication scheme and professional negligence claims. So joining me this morning and presenting for you are Alison Garrett. Alison's a senior legal advisor in our construction and engineering team, and also Peter Lennon. And Peter is one of our trainee solicitors here at Mills & Reeve. For those of you who don't know me already, my name is Neil Howes. I'm a partner here at Mills & Reeve. So just a couple of things before we start. We are recording this session and we publish it afterwards. These are bite-sized webinars, so we don't necessarily have a Q&A at the end. But if you do have any queries as we're going along, then do use the chat function at the bottom of your screens. And if you leave us a question, we will do our very best to respond to you by email. And we do have a couple of poll questions that we'll be asking at the end, hopefully so that you can kind of put some of the knowledge that you're learning into practice. So let's make a start then. Today's session, all about construction adjudications. Let's jump in. Alison, what is construction adjudication? How does it work?
Well, construction adjudication is required by the Housing Grants Construction and Regeneration Act. It came into force in the late 1990s, and it's a statutory right to adjudicate, which applies to all construction contracts. It's rough and ready, by which I mean it's usually about 35 days from start to finish. So as you can see, that's much quicker than court proceedings would be. And as I just mentioned, it applies to all construction contracts. And if you have a construction contract, either party can refer a dispute under that construction contract to adjudication at any time. It's also worth noting you cannot contract out of the right to adjudicate. If you've got a construction contract, and professional negligence contracts can be construction contracts, then you're stuck with the right to adjudicate. The other point to mention at this point in time is if your contract does not provide specifically for adjudication, but you've got a construction contract, the scheme for construction contracts will be deemed to apply. And what that scheme introduces is a procedure for how the adjudication will proceed. So it's important to bear in mind that you can be caught by adjudication even if your contract says nothing about it, and there's a process that applies even if your contract says nothing about it.
Alison, you mentioned there that adjudications take place over quite a tight time scale. Just how tight are we talking?
Well, as I said, it can be about 35 days from start to finish. And on the slide on the screen at the moment, I've set out an idea about how an adjudication might run. And this is a pretty standard sort of adjudication. You can get adjudications extended beyond 35 days, but most adjudicators will try their very best to complete it within that time frame. 35, I'm talking about 35 calendar days, not working days as well, so it's pretty tight. So here I've set out what you might anticipate. On day one, the party bringing the claim will issue a notice of intention to refer a dispute to adjudication, and that's served on the other party. And then at the same time, they will apply to a nominating body. That's somebody like the Royal Institute of Chartered Surveyors, the RIBA, the Royal Institute of British Architects, or sometimes TEXA, the Technology and Construction Solicitors Association. And those bodies will appoint an adjudicator, and they will usually do it really quickly, within 2 or 3 days. So once the adjudicator has been appointed, the referring party serves their referral notice. That's, for those of you familiar with court proceedings, that's really what you would regard as your statement of case. And that gets served no later than 7 days after the original first notice. The adjudicator then gives the responding party some time to serve a response, but because the time frame is so tight, he or she can't give the responding party a long time. It's usually about 7 to 10 days, calendar days again. So, you know, write off any social activities you had for that weekend. You will be preparing your response instead. You then get other pleadings in adjudication, the reply by the referring party, possibly a rejoinder by the responding party, and other pleadings. So you can get more responses backwards and forwards than you get in court proceedings, but they tend to be called the formal name for the pleading, but they're actually often no more than a letter. There's no disclosure. It's up to the adjudicator whether they hold a meeting or not, and the decision is made within 35 days. One other point just to bear in mind, a key point in relation to adjudication, each party usually pays their own costs. Whatever the outcome of the adjudication, they both remain liable for the adjudicator's fees. So if the adjudicator orders one party to pay their fees and that party fails to do so, the other party has to pay them.
So the timescales are obviously really, really tight. Can the responding party ask for an extension of time? And if so, does the referring party have to consent? How does that work?
An extension of time beyond the 35 days?
Yeah.
The normal position is that any extension of time beyond the 35 days, the first 14 days extension of time, has to be granted at the consent of the referring party only. And if you're the referring party, you may not want to give extra time. It may not suit you. You've got a responding party under pressure. After any first 14-day extension, any further extension sought after that has to be with the agreement of both parties. So the responding party alone has very little control over an extension.
We've talked about the process, we've talked about the timescales. What are the kinds of construction disputes that commonly get referred to adjudication? And what about professional negligence claims? Are they suitable for determination using the adjudication procedure? Well,
sort of slightly turning on its head, in terms of professional negligence claims, they can be referred to adjudication. Any dispute under any construction contract can be referred to adjudication at any time, and there is no limit on that. The original intention was really to resolve disputes between contractors and subcontractors with regard to payment, but the Act did not limit the type of dispute that can be referred in any way. So we do see professional negligence claims coming through adjudication. We also see lots of quite complex claims to do with extensions of time and loss and expense. They all come through adjudication, or they can all go through adjudication, should I say.
So having heard a little bit about how adjudication works, I know that there'll be a number of insurers, brokers on the call today. Peter, from the professional's perspective and from a policy coverage perspective, what does the professional need to bear in mind?
Sure. So when a claim against a construction professional is referred to adjudication, there are a number of potential policy coverage issues that need to be considered. Every PI policy is different, but all PI policies will contain provisions that require the professional to notify insurers within a certain timescale if they become aware that a claim is being made against them, or if they become aware of circumstances that may give rise to a claim or that are likely to give rise to a claim, depending on the policy wording. The key point is that most PI policies will also include special notifications relating to adjudication, notification conditions. Typically, if the professional receives a notice of adjudication or a referral notice, those conditions will require them to notify that to insurers within 2 working days. Now, those notifications, whether under an ordinary provision or a provision relating to adjudication, are important because it's the notification which triggers cover under the policy. In many cases, compliance with the notification provision is also a condition precedent to liability under the policy. In other words, what that means is that if the professional doesn't comply with the condition, they are likely to be left without cover. Now, in the case of a 2 working day provision, that may sound quite harsh, but it reflects the fact that because of the short timescales on adjudication, which Alison has just set out, the insurer will have a very limited amount of time to appoint solicitors and to submit its response to the claim. Now, aside from notification provisions, most PI policies will also include various other conditions relating to adjudication. Many of those conditions are also likely to be conditions precedent to liability. All of those conditions will be in place to ensure that insurers' rights to defend the claim aren't prejudiced. As a practical example, many contractors' PI policies we would expect to contain a condition that the contractor's contracts with its employers and with its subcontractors must not include any provisions that would make any adjudicator's decision final and binding on the parties. Again, that may be a condition precedent to liability under the policy. So as always, it's worth checking your policy wording.
So we've talked about conditions in policies that might be directly relevant to adjudication, but from the insurer's perspective, what other policy coverage issues do they need to be kind of bearing in mind and thinking about when an adjudication lands?
Of course. So when any claim is notified to insurers, there are a number of other points that insurers need to check before they can decide whether the claim is covered. That will be familiar to many listeners. The difficulty posed by adjudication is that, as we've discussed, the timescales are extremely tight. As a result of that, insurers have very limited time, if really any time at all, to consider coverage once a notification of adjudication has been received. That's particularly the case if the professional, the insured, didn't have advance warning themselves that a claim was going to be made, if it's being made in sort of an ambush situation. As a practical example of a coverage issue that can arise, the PI insurance you would expect to see for a design and build contractor would cover them for claims arising from design, but not for liabilities arising as a result of their own poor workmanship. When a claim is first notified, it might not be easy to determine whether the alleged losses relate to design, whether they relate to workmanship, or whether they relate to a combination of the two. That is often a situation that requires expert evidence. And given the strict deadlines for adjudication, it's extremely unlikely that you'll be able to obtain expert evidence in time. What we often see in practice is that insurers will agree to fund the adjudication in the short term, and that funding may be made without prejudice to any coverage points which are identified after the adjudication has finished and after the dust has settled, so to speak.
And presumably, doing it that way helps and protects the insured's position, but it also preserves the insurer's position going forward. And of course, there's a kind of mutual beneficial interest to both parties in having the adjudication defended, assuming there's obviously a defence available to the claim. So we've touched upon policy coverage. Turning now back to the adjudication process itself, Alison, we've talked about how the adjudicator reaches a decision, but once that decision is given, how is it enforced?
Well, it's enforced through the Technology and Construction Court. They have a specialist system for adjudication, whereby proceedings can be issued and an abridged summary judgment application will be heard within 1 or 2 months of the issue of proceedings. So very, very much quicker than the court would normally operate. And I think it's fair to say that judgment will usually be granted. There are very few circumstances in which the court won't grant judgment. Those might be challenges in relation to jurisdiction, breach of natural justice or fraud. Breach of natural justice or fraud don't happen very often, and neither does jurisdiction. But there are some jurisdictional challenges that have been successful. And if you are a responding party and you think there are issues about jurisdiction, perhaps you don't think there was a dispute when the action was brought, when the adjudication was brought, always worthwhile flagging jurisdiction in all correspondence from the start of adjudication onwards. Not least because if you're short of time, and you usually will be if you're a responding party, it may mean that the adjudicator chooses at that point to resign, giving you a bit more breathing space before the next inevitable adjudication is started. And when it's on such tight timeframes, you may need those extra few days. That's slightly tangential to what I've just been saying. Judgment will usually be granted. Jurisdiction is one of the few bases on which a court might refuse judgment. The courts treat a stay of execution separately to a judgment. So they may give a judgment on summary on an adjudicator's decision, and they may choose to stay execution. But that again is very rare. The sort of situations when they will relate primarily to insolvency. But again, we're talking about a company in liquidation, or if the party has acknowledged that it is insolvent in some shape or form. Administration, or just a feeling that the company can't pay its debts as they fall due, is not likely to be a good enough reason. One other reason that's become clear recently is if a company chooses to organise its financial affairs with the purpose of disposing of the adjudication sum. And when we talk a little bit more about the temporary nature of adjudication, perhaps why that's an issue might become a bit clear, i.e. the inability to get the money back again if need be.
Yeah. So you mentioned there, obviously, the possibility of challenging the adjudicator's decision on jurisdictional grounds, and the adjudicator not having a jurisdiction to have determined the dispute. I mean, there may presumably be other cases where the adjudicator has made a decision. As a responding party, you fundamentally disagree with the conclusion that they've reached. You also mentioned it's a temporarily binding process. So how do you go about challenging an adjudicator's decision if you just think that they've got it wrong?
Well, I think there's several things in what you've just said there, Neil, that are worth picking up on. If the adjudicator's decision is just wrong, then you are bound by it. And perhaps some of the best examples of that are if they get the maths wrong. Bearing in mind they've got such a short period of time in which to deal with these claims, that's not surprising. They have a period of, I think it's 5 days, to correct basically a typographical or possibly a mathematical error under the slip rule, but otherwise you're stuck with the adjudicator's decision. It's described as temporarily binding because the original intention of adjudication was, as I said at the beginning, to try and sort out payment issues between contractors and subcontractors. And the idea was that adjudication would enable a subcontractor to get paid, and then the parties would carry on with the contract. And it was simply an issue of cash flow. The subcontractor got the cash. If the parties strongly disagreed with the decision of the adjudicator, or if the contractor disagreed, they could go off after they'd paid the adjudicator's award and apply to or issue court or arbitration proceedings, depending on what the contract said, to have the whole matter reviewed again, almost as if the adjudication process didn't exist, and you were just asking your final dispute resolution forum to deal with the claim. How does this work in relation to professional negligence claims? What it means is if there's been an award against a party, they have to pay it. They then can go off and ask a court or an arbitrator, depending on what their contract says, to review the whole thing again. But there are difficulties with that. As I said, you have to pay the sum in the meantime. You also have slightly one hand tied behind your back, because unless the adjudicator's gone completely off the point, you're issuing proceedings when you know there's an adjudicator's decision, somebody's thought it through and decided against you. So really, in practice, unless you're talking about a huge amount of money and an obviously wrong decision, it's not usually commercially worthwhile taking it to court or arbitration.
So there are avenues if you need them and should you need them, but it's very much a kind of pay first, challenge later kind of regime.
Very much so. And I think if you think about the reason for it, the fact that it was to deal with subcontractor concerns, that helps to understand how it's intended to work.
Yeah, it feels at times slightly counterintuitive, doesn't it?
Yeah.
But at the same time, actually, once you strip it back and you think about the reasons why the scheme was put in place in the first place, it does make sense.
Yes, it does. Whether it quite works for professional negligence or other complex claims is another matter.
So let's touch on that then, because I skipped over a slide a little bit later, a bit earlier, but I thought it was worth kind of coming back to that at the end in just pulling all of those strands together, if you like. What are the pros and cons as you see them, Alison, of adjudication?
Well, the key pros are it's quick, relatively quick. Court proceedings, if you're lucky, you'll be talking about 18 months from start to finish. In adjudication, you're probably talking about a maximum of a couple of months. So from that perspective, it gets the matter resolved. It's also comparatively cheap. It's no longer quite as cheap as it was, but it is a lot cheaper than court or arbitration proceedings. And as I've said, it will usually, and this is a plus point, if you're the party who benefits from the adjudicator's decision, it will usually be enforced by the courts and quickly. The cons, and one of the big cons for the responding party, as I see it, is that what the slide says is the referring party can manage the timetable. There is no limit on the time that the referring party can take to prepare its case before it commences adjudication. So it could take 6 months to prepare its case, but the responding party will get, as I said, about, if they're lucky, 7 to 10 days to respond. So it's a bit unbalanced in that respect if you're the responding party. And again, the flip side of being enforced by the court is you're bound by the decision, if you like, whether you like it or not. It's a question of pay now, argue later, unless you've got jurisdictional issues, or there's been a breach of natural justice, or the receiving party is in a dire financial situation.
Dire financial straits. Well, thank you very much for that. We mentioned just then jurisdictional challenges, and that being used, potentially in some cases to effectively challenge adjudicators' awards. And with that in mind, we thought we would finish today with a poll, which I'm hoping I'm now going to be able to run. So here you go. So hopefully you can all see that on your screens. Which of the following is not a valid reason for challenging an adjudicator's jurisdiction to determine a dispute? Firstly, there was no dispute in existence between the parties at the time of the notice of adjudication. Secondly, the contract between the parties sets out the procedure for appointing an adjudicator, and that process hasn't been followed. 3, dispute is far too complex to be dealt with in 28 days. And 4, there's already been an adjudication of the same dispute. So which of those is not a valid reason for challenging an adjudicator's jurisdiction? What do you think? Quite a wide range of answers coming in, and the front runners, well, it's neck and neck at the moment. I'm just going to give it 10 more seconds, and then we're going to stop it there, and hopefully I'll be able to share the results with you. So there you go. So actually neck and neck, not a lot of love for answers 1 and 2. Quite a lot of people thought actually you can't challenge jurisdiction just on the basis that the dispute is far too complex to be dealt with in 28 days. And also a lot of love for there's already been an adjudication on the same dispute. So Alison, what's the answer? Which is the reason that you can't use to challenge jurisdiction?
The actual reason is number 3, the dispute is far too complex to be dealt with in 28 days. The other reasons are not good grounds to challenge, are good grounds to challenge a decision of an adjudicator. The number 1, there was no dispute in existence between the parties. That is a good ground to challenge on the basis of a lack of jurisdiction of the adjudicator if there is in fact no dispute. Number 2, if there's a procedure set out for the parties to adopt in terms of adjudication and they do not follow it, and for instance if they don't go to the right nominating body, any adjudicator appointed would not have jurisdiction again. And number 4, there's already been an adjudication on the same dispute. I feel a bit sorry for people who answered number 4 because it's quite a tricky point. You can't adjudicate on the same dispute more than once, so it's a jurisdiction issue again.
one of the interesting points is on point 1. If there's no dispute in existence between the parties at the time when the notice to adjudicate was served, so presumably, and this must happen sometimes, is that you get an adjudication notice completely out of the blue. The professional doesn't know that there's a dispute in the offing at all, and then suddenly gets landed with a notice to adjudicate. And that presumably is one of those cases where you can challenge the adjudicator's jurisdiction.
Yes, it does happen. What happens quite often as well is that a party will receive a letter which will say something along the lines of, we believe there's a dispute between us. And unless you are au fait with how adjudication works, it's very easy to just dismiss that and move on. But in fact, that might be an indication that one party is trying to set up a dispute. So although you can't sift through every single letter looking for the word dispute, if you see something that refers to dispute in a letter, or says that the parties believe there is, or one of the parties believes there's a dispute, watch out. It could be the forerunner to an adjudication.
It could be a precursor to what has become, what might be to come. Well, that's all we've got time for today, folks. I hope you have found this session useful. Just a big thank you to Alison and to Peter for talking to us today. We're going to be taking a break over the summer, but we will be back with Breaking Ground in mid-September. So we look forward to seeing you all there. In the meantime, as you log off, please do fill in the feedback forms that you'll see on your screen. We love to get your feedback, particularly your views on topics that you'd like us to cover in future editions of Breaking Ground. So we'll be back in September. In the meantime, enjoy the summer sunshine whilst it lasts, and we'll see you all soon.